Introduction to Notarization. Notarization is a critical process that authenticates signatures on documents, ensuring their integrity and preventing fraud. It involves a neutral third party, the notary public, who verifies the identity of the signer and witnesses the signing of the document. This act adds a layer of legal validity and trustworthiness, making the document admissible in courts of law. Understanding the fundamental purpose of notarization is the first step in becoming a proficient notary. The process of notarization is essential in various legal and financial transactions, especially within the real estate sector. It safeguards against forgery and ensures that parties willingly enter into agreements. By confirming identities and observing signatures, notaries play a vital role in maintaining the integrity of legal instruments. This course will delve into the specific applications and requirements for notarizing real estate documents. Role of a notary public. A notary public serves as an impartial witness to the signing of important documents and administers oaths and affirmations. Their primary duty is to deter fraud and ensure that the signers are who they claim to be, and that they are signing willingly. Notaries do not offer legal advice or prepare documents, maintaining their role as neutral facilitators. This impartiality is crucial for the validity of the notarial act. The responsibilities of a notary public extend to verifying identities, ensuring comprehension of the document, and recording the notarial act in a journal. They must remain vigilant against coercion and fraud, acting as a public servant to protect consumers. Adherence to state laws and ethical guidelines is paramount for every notary public. Their role is one of trust and diligence. Ethical principles for notaries. Ethical conduct is the cornerstone of a notary public's profession, demanding unwavering integrity and impartiality. Notaries must never notarize a document in which they have a personal interest or financial stake. They must also avoid providing legal advice, which could constitute the unauthorized practice of law. Maintaining strict confidentiality regarding the contents of documents is another vital ethical obligation. Key ethical principles include always verifying the signer's identity thoroughly and ensuring they appear willing and aware of what they are signing. Notaries must refuse to notarize if they suspect fraud, coercion, or if the signer is not mentally competent. Upholding these ethical standards protects both the public and the notary from legal repercussions. Professionalism and adherence to the law are non-negotiable. Legal framework of notarization. Notarization is governed by state-specific laws and regulations, which dictate the powers and duties of a notary public. These laws cover appointment requirements, authorized notarial acts, fees, and record-keeping obligations. Federal laws may also apply to certain documents, particularly those related to international transactions or specific federal programs. Notaries must be thoroughly familiar with the statutes in their commissioning state. Understanding the legal framework is crucial to avoid errors and potential liability. Notaries must stay informed about any changes to their state's notary laws and administrative rules. Ignorance of the law is not a valid defense for improper notarial acts. Compliance with these regulations ensures the validity of the notarization and protects all parties involved in a transaction. Understanding real estate documents. Real estate documents are legal instruments that transfer, encumber, or define interests in property. These documents are diverse, ranging from deeds and mortgages to leases and easements. Each type has specific legal implications and often requires notarization to be legally binding and recordable. Notaries must be able to identify these documents and understand their general purpose to perform appropriate notarial acts. Familiarity with common real estate terminology and document structures is essential for notaries. While notaries do not interpret legal content, recognizing the document type helps them ensure the correct notarial certificate is used. This knowledge also assists in identifying potential red flags or unusual requests that might warrant refusing a notarization. A strong understanding of these documents enhances a notary's professionalism and efficiency. Deeds, types, and notarization. Deeds are fundamental real estate documents used to transfer ownership of property from one party to another. Common types include warranty deeds, quitclaim deeds, and special warranty deeds, each offering different levels of protection to the grantee. Notarization of deeds is almost universally required to ensure the grantor's identity and willingness to transfer ownership, making the document recordable with the county recorder's office. This step is crucial for establishing clear title. When notarizing a deed, the notary must verify the identity of the grantors and witness their signature. The notarial certificate typically used for deeds is an acknowledgement, confirming that the signer personally appeared and acknowledged signing the document. It is important for the notary to ensure the document is complete before notarization, though they should not fill in blanks or offer advice on its content. Proper notarization validates the transfer of property. Mortgages and deeds of trust. Mortgages and deeds of trust are security instruments that pledge real property as collateral for a loan. A mortgage involves two parties: the borrower, mortgager, and the lender, mortgagee. A deed of trust typically involves three parties: the borrower, the lender, and a neutral third-party trustee. Both documents grant the lender the right to foreclose on the property if the borrower defaults on the loan. Notarization is essential for these documents to be legally enforceable and recordable. The notarization process for mortgages and deeds of trust primarily involves verifying the identity of the borrowers and witnessing their signatures. An acknowledgement certificate is commonly used for these instruments, confirming the signer's voluntary execution of the document. Notaries must ensure all parties are present, willing, and competent to sign. Accurate notarization protects both the lender's interest and the borrower's rights, ensuring a legally sound transaction. Promissory notes and liens. Promissory notes are written promises to pay a specific sum of money to another party, often used in conjunction with mortgages or deeds of trust in real estate transactions. While the promissory note itself does not typically require notarization to be legally binding, it is frequently notarized as a best practice to provide additional proof of authenticity. This extra step can be crucial in case of disputes over the debt. It solidifies the commitment to repayment. Liens such as mechanics liens or judgment liens are legal claims against a property to secure payment of a debt. The documents creating or releasing these liens, like a release of lien, no actual text visible, often require notarization to be recorded and effective. Notarizing these documents involves verifying the identity of the party granting the release or creating the lien. The proper notarial act, usually an acknowledgement, ensures the document's validity and recordability, protecting the interests of all parties involved. Power of attorney for real estate. A power of attorney for real estate grants one person, the agent or attorney in fact, the authority to act on behalf of another, the principal, in property-related matters. This can include buying, selling, leasing, or managing real estate. Notarization of a real estate POA is almost always required to ensure its legal validity and acceptance by third parties, such as title companies and financial institutions. It confirms the principal's intent and capacity. When notarizing a real estate POA, the notary must verify the identity of the principal and witness their signature. The notarial act is typically an acknowledgement, confirming that the principal voluntarily signed the document. It is crucial to ensure the principal appears competent and understands the significant authority they are granting. Notaries must never notarize a POA if they suspect duress or lack of capacity. Proper notarization empowers the agent to act legally on the principal's behalf. Affidavits and declarations. Affidavits and declarations are written statements of fact made under oath or affirmation, used as evidence in legal proceedings or transactions. In real estate, they can be used for various purposes, such as confirming property boundaries, marital status, or the absence of liens. Notarization is essential for affidavits and declarations to attest that the signer swore or affirmed the truthfulness of the statement before a notary. This adds credibility and legal weight. The notarial act for affidavits and declarations is typically a jurat, where the signer takes an oath or affirmation before the notary and signs the document in the notary's presence. The notary must verify the signer's identity and administer the oath clearly. It is critical that the notary does not draft the affidavit or advise on its content. The notary's role is strictly to witness the oath and signature, ensuring the statement's sworn authenticity. Lease agreements and amendments. Lease agreements are contracts between a landlord and a tenant, granting the tenant the right to occupy a property for a specified period in exchange for rent. While many residential leases do not legally require notarization, commercial leases or long-term leases, often exceeding 1 year, may require it, depending on state law. Notarization, when required or chosen as a best practice, adds an extra layer of authenticity and can prevent disputes over signatures. It ensures the parties are who they claim to be. When notarizing a lease agreement or an amendment, the notary must verify the identities of the parties signing, landlord and/or tenant, and witness their signatures. An acknowledgement is the typical notarial act used for these documents. The notary should ensure the document is complete and that the signers appear willing and competent. Proper notarization helps ensure the enforceability of the lease terms and protects both parties' interests in the property rental agreement. Escrow and closing documents. Escrow and closing documents are a comprehensive set of papers exchanged at the culmination of a real estate transaction. These include the closing disclosure, settlement statements, and various affidavits and agreements. Many of these documents require notarization to finalize the transfer of ownership, secure financing, and ensure all legal requirements are met. The sheer volume and complexity of these documents necessitate a notary's careful attention. They are the final steps in a property sale. A notary public at a real estate closing must be prepared to notarize multiple documents for various parties, including buyers, sellers, and lenders. The most common notarial acts performed at closings are acknowledgements and jurats. The notary must meticulously verify the identity of each signer for every document and ensure they understand what they are signing. Precision and efficiency are paramount during these high-stakes transactions, as errors can cause significant delays or legal issues. Notarial acts. Acknowledgements. An acknowledgement is the most common notarial act used to verify that a signer has voluntarily signed a document. In this act, the signer personally appears before the notary, presents valid identification, and declares that they signed the document for the purposes stated therein. The notary then completes an acknowledgement certificate attesting to these facts. This act does not confirm the truthfulness of the document's content, only the authenticity of the signature and the signer's intent. The key steps for performing an acknowledgement include verifying the signer's identity using acceptable forms of identification, ensuring the signer appears willing and competent, witnessing the signer's declaration that they signed the document, completing the acknowledgement certificate, including the notary's signature and seal. This process is fundamental to notarizing most real estate documents, providing legal proof of the signer's consent. Notarial acts. Jurats. A jurat is a notarial act where the signer swears or affirms to the truthfulness of the contents of a document. Unlike an acknowledgement, a jurat requires the signer to take an oath or affirmation before the notary, stating that the information in the document is true to the best of their knowledge. The signer must also sign the document in the notary's presence. This act is commonly used for affidavits and sworn statements. The process for a jurat involves verifying the signer's identity, administering an oath or affirmation to the signer, witnessing the signer affix their signature to the document, completing the jurat certificate, which includes the notary's signature and seal. The notary's role is to ensure the oath is taken and the signature is witnessed, adding legal weight to the veracity of the document statements. This act is crucial for documents where the content's truthfulness is paramount. Notarial acts. Oaths and affirmations. Oaths and affirmations are solemn declarations made by a signer regarding the truthfulness of a statement. An oath is a religious or spiritual appeal, while an affirmation is a secular, equally binding declaration. Notaries administer these to signers for documents like affidavits or depositions, where the content must be sworn to be true. The notary's role is to ensure the signer understands the gravity of their declaration and makes it voluntarily. When administering an oath or affirmation, the notary must verify the signer's identity, ask the signer if they swear or affirm that the statements in the document are true, ensure the signer responds affirmatively, witness the signer's signature on the document. This notarial act is critical for documents where the veracity of the information is legally significant. The notary acts as a witness to the signer's commitment to truthfulness, adding legal weight to their statements. Verifying signer identity. Verifying the signer's identity is the most crucial step in any notarial act, preventing fraud and ensuring the integrity of the document. Notaries must rely on acceptable forms of identification, which typically include government-issued photo IDs, like a driver's license or passport. The ID must be current, contain a photograph, a physical description, and a signature. Notaries must carefully examine the ID for any signs of tampering or alteration. If a signer lacks traditional identification, some states allow alternative methods, such as credible identifying witnesses. These witnesses must personally know the signer and be known to the notary, or present satisfactory identification themselves. Notaries must document the method of identification used in their journal. Under no circumstances should a notary proceed if they have any doubt about the signer's identity. Diligence in identity verification is paramount. Dealing with challenging signers. Notaries may encounter challenging situations with signers, such as those who are hesitant, uncooperative, or appear to be under duress. It is the notary's responsibility to assess the signer's willingness and mental competence. If a signer seems confused, pressured, or unable to understand the document, the notary must refuse to perform the notarial act. The notary's primary duty is to protect vulnerable individuals and prevent fraud. Other challenges might include signers who do not speak English, requiring a qualified translator, though the notary must still communicate directly with the signer to ensure willingness. Notaries must also handle situations where a signer refuses to provide proper identification or insists on an illegal notarial act. In all such cases, maintaining professionalism, documenting the refusal in the journal, and adhering strictly to state laws are essential. The notary's judgment is critical. Notary journal requirements. Maintaining a detailed notary journal is a mandatory requirement in many states and a best practice everywhere. The journal serves as a chronological record of all notarial acts performed, providing a crucial audit trail and protecting both the notary and the public. It typically includes information such as the date and time of the act, the type of notarial act, the document type, the signer's name, and the method of identification used. Signers are usually required to sign the notary journal entry for their transaction. The journal should be kept securely and confidentially, accessible only to the notary and authorized legal entities. Proper journal keeping is vital for demonstrating compliance with state laws and can be invaluable in defending against claims of misconduct. It is a notary's primary record of their official duties. Notary seal and certificate. The notary seal is an official device used to authenticate the notary's signature on a notarial certificate. It typically contains the notary's name, the words Notary Public, the commissioning state, and the expiration date of the commission. The seal must be legible and applied clearly to the notarial certificate. Many states specify whether an embosser, an ink stamp, or both are required. The seal is a visual representation of the notary's authority. The notarial certificate is the written statement completed by the notary, attesting to the facts of the notarial act. It is attached to or printed directly on the document being notarized. The certificate must include specific wording required by state law, the notary's signature, and the impression of the notary seal. Errors in completing the certificate can invalidate the entire notarization, making meticulous attention to detail essential. A correctly completed certificate is proof of a valid notarial act. Common notarization errors. Notarization errors can lead to serious legal consequences, including invalidating documents, financial penalties, and even loss of commission. Common mistakes include failing to properly verify identity, neglecting to complete the notary journal, or using an expired notary seal. Other errors involve notarizing a document with blank spaces, providing legal advice, or notarizing for a signer who is not physically present. These errors undermine the integrity of the notarial act. To avoid errors, notaries must meticulously follow state laws and established best practices. This includes carefully reviewing documents for completeness, ensuring the notarial certificate wording is correct, and always requiring personal appearance and valid identification. Continuous education and attention to detail are the best defenses against making mistakes. Understanding common pitfalls helps notaries perform their duties accurately and confidently. Remote Online Notarization, RON. Remote Online Notarization, RON, allows notaries to perform notarial acts for signers who are not physically present using audio-visual technology. This modern approach has gained significant traction, especially in real estate, offering convenience and accessibility. RON is permitted in an increasing number of states, each with specific technological and procedural requirements. It leverages secure platforms to ensure identity verification and document integrity. The RON process typically involves multi-factor authentication of the signer's identity, live, two-way audio-visual communication between the notary and signer, electronic signing of documents, electronic application of the notary's seal and signature, creation of an audio-visual recording of the entire notarial act. Notaries must be specifically commissioned or authorized for RON in their state and use approved technology platforms. RON offers efficiency, but demands strict adherence to enhanced security protocols. Notarizing for special circumstances. Notaries may encounter special circumstances that require careful consideration and adherence to specific guidelines. These can include notarizing for individuals with disabilities, signers in hospitals or nursing homes, or those who are incarcerated. Each situation demands sensitivity, strict compliance with laws regarding capacity and willingness, and often requires additional documentation or witnesses. The notary must ensure the signer is fully aware and capable. Another special circumstance involves notarizing for foreign language speakers. While the notary must communicate directly with the signer, a qualified, impartial translator may be used to facilitate understanding, but the notary cannot act as the translator. Notaries must also be aware of rules regarding notarizing for minors or individuals with power of attorney. In all special cases, the notary's paramount duty is to ensure the integrity of the notarial act and protect the signer's rights. Record keeping and retention. Beyond the notary journal, notaries are often required to retain copies of certain documents or related records. This can include copies of the notarial certificate, identification documents presented, or specific real estate instruments. State laws dictate the types of records to be kept and the required retention period, which can range from several years to indefinitely. Proper record keeping is essential for legal compliance and protection against liability. Organizing and securely storing these records is paramount. Notaries should implement a systematic filing system, whether physical or electronic, to easily retrieve records when needed. Confidentiality and data security are critical, especially for sensitive personal information. Failure to maintain adequate records or to retain them for the specified period can result in penalties. Diligent record keeping reinforces the notary's professionalism and accountability. Liability and insurance for notaries. Notaries public can face significant liability for errors, omissions, or misconduct in their duties. Mistakes, such as failing to verify identity or improperly completing a certificate, can lead to financial damages for affected parties. Notaries are personally responsible for their actions, and lawsuits can arise from negligence or intentional wrongdoing. Understanding potential liabilities is crucial for risk management. To protect themselves, notaries should consider obtaining errors and omissions E&O insurance. This insurance covers legal defense costs and damages resulting from unintentional mistakes or omissions made during notarial acts. While some states require a notary bond, which protects the public, E&O insurance protects the notary. Investing in adequate insurance is a prudent step for any notary public, especially those frequently handling high-value real estate transactions. Continuing education for notaries. The legal landscape surrounding notarization and real estate documents is constantly evolving, making continuing education vital for notaries. Laws change, new technologies emerge, like RON, and best practices are refined. Staying informed ensures that notaries remain compliant with current regulations and can competently perform their duties. Many states mandate continuing education as a requirement for commission renewal. Continuing education can take various forms, including online courses, workshops, and seminars offered by state notary associations or approved providers. These programs cover updates to notary law, ethical guidelines, and specialized topics like real estate notarization. Investing in ongoing learning not only fulfills legal requirements, but also enhances a notary's expertise, professionalism, and confidence in their role. It is an essential commitment to excellence. Conclusion and best practices. Mastering the notarization of real estate documents requires a thorough understanding of legal principles, ethical obligations, and meticulous procedural execution. Notaries play a crucial role in safeguarding property transactions, preventing fraud, and ensuring the legal validity of critical instruments. Adhering to state laws, maintaining impartiality, and diligently verifying identities are foundational best practices for every notary public. To excel in this specialized field, notaries should commit to ongoing professional development, invest in E&O insurance, and maintain impeccable records. Always prioritize the signer's understanding and willingness, and never hesitate to refuse a notarization if any doubt arises. By consistently applying these best practices, notaries can confidently and competently serve the public and the real estate industry, upholding the integrity of their office.